case number 251740SM. Appearances, counsel?
Nick Carnes on behalf of the people.
Herself, Ms. Jones, you come over here.
We are set for a pretrial conference. It appears we have a resolution in this matter, Mr. Carnes.
Yes, Your Honor. It's my understanding the defendant will be pleading no contest as charged. The people are supporting a delay of sentence with a full dismissal if the defendant is successful on the delay. Success on the delay would be whatever programming is recommended by probation and no violations of typical probation conditions.
Is that a Killebrew?
Yes.
Okay.
And the reason for the no contest plea is potential civil liability, Your Honor.
And so just so we're clear, the success is completion of programming and no violations.
Correct, Your Honor.
Mr. Hussell?
That is accurate, Your Honor.
Ms. Jones, have you heard what the attorneys have said the resolution in this case is?
Yes.
And is that how you wish to resolve it?
Yes.
Will you please raise your right hand? You solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth.
Yes.
Ms. Jones, it's my understanding that the agreement today is that you will plead no contest to assault and/or assault and battery. That is a 93-day misdemeanor and/or a fine of $500, and consecutive sentencing may be imposed if the offense happened in a place of confinement. Now, along with that, there's what's called a Killebrew agreement. And what that is the prosecution and your attorney and you have reached an agreement that you'll be placed on a delay of sentence. And if you're successful with that delay of sentence, the case would be dismissed. Success means that you complete all the programming that your probation officer requests that you do, and you not have any violations. Do you understand that?
Yes.
Now, if I decide that I do not want to go along with that agreement, you have the option to withdraw your plea. Do you understand that?
Yes.
Additionally, this is going to be a no contest plea due to potential civil liability. What that means is that the alleged victim in this case could potentially sue you for any damages in which she's incurred. A no contest plea allows me to read a document, looks like it's going to be a police report, and use that police report to determine whether or not there's a factual basis to accept the plea and to use that for sentencing purposes. Do you understand that? Additionally, a no contest plea cannot be used against you. So if you are going to plead guilty and this person sued you, that guilty plea could be used against you. The no contest plea means that it's not. Essentially, you're accepting responsibility without saying that you did it. Do you understand that?
Yeah.
And is that how you wish to proceed?
Yes.
Back on March 31st of this year, were you on probation or parole?
No.
Were you on bond in any other file?
No.
Then Ms. Jones, to the offense that on or about March 31st, 2025, here in the city of Cadillac of Wexford County, how do you plead to committing the offense of assault and/or assault and battery?
No contest.
Counsel, I've been provided with a Cadillac Police Department report, incident number 2500819. It's been marked as People's Exhibit number 1. Mr. Carnes, do you move for its submission?
Yes, Your Honor.
Mr. Hartel?
Yes, Your Honor.
No objection then. The People's Exhibit number 1 is received. Give me just a moment to review that. Here we are back on the record. I've had the opportunity to review the People's Exhibit number 1. Do counsel believe that it forms a factual basis in which to accept the plea and that the court rules have been complied with?
Yes, Your Honor.
Yes, Your Honor.
As does the court. I find the plea is knowing, voluntary, and accurate. As such, Ms. Jones, I find you guilty of assault and/or assault and battery. In particular, on March 31st, 2025, there is a video that shows Ms. Jones hitting, kicking, kneeing as the victim is lying in a fetal position by what's commonly referred to as the old dam. The court can take judicial notice that is located here in the city of Cadillac and is between Haynes Street and River or Wright Street on the what's now known as something along the lines of the green trail or the green pathway. The victim is a 14-year-old middle schooler. The victim reported that she had no injuries. It is alleged in the police report that Ms. Jones posted another video on TikTok captioned round 2. And this appeared to be all over some things that were said about another's deceased mother. As such, I find that the elements are made out for an assault and battery, and that this would have been an unwanted, forceful, violent touching. Additionally, I believe the interests of justice are well established here in allowing the defendant to plead a no contest so as to not have her guilty plea used against her should a case of civil liability arise, although I question what the civil liability would be since there's no injuries, but I guess that's not for me to determine.
Amanda Jones, an 18-year-old, appeared before Judge Hartle in Michigan, charged with misdemeanor assault and battery for allegedly attacking a 14-year-old girl. According to the case, the incident was recorded on video, and afterward Amanda allegedly posted another TikTok video with the caption "Round 2." During the hearing, both attorneys informed the judge that Amanda would enter a no contest plea. In return, they requested a delayed sentence agreement, meaning if she successfully completed probation requirements and stayed out of trouble, the case would eventually be dismissed. The judge carefully explained what a no contest plea meant and confirmed that Amanda understood the agreement before accepting her plea.
Mr. Carnes, are we able to sentence today?
Yes, Your Honor.
Mr. Hartel, any allocution?
Yes, thank you, Your Honor. Anytime it's no contest, especially for civil liability, I'm cautious to overly allocute for obvious reasons. But what I will say is my client has, to my knowledge, done well on bond. She stayed in constant contact with the defender's office, been very cooperative. She does have strong ties to the community. I don't doubt she'll do well on probation. She's highly motivated to do well and receive the benefit of the delay. I, in these situations, always advise my clients if they don't do well, there is the risk of jail later, the loss of the delay, the public adult record. She's a relatively young adult. She wants to be able to pursue various careers and ambitions. At the moment, she's working at Qdoba. She's aware she owes some money on some older files, but she is going to, I believe, do a wage assignment, if I understand that correctly. She also has some friends with her in the courtroom who've been supportive throughout these procedures, and I don't doubt will continue to be supportive of her as well. I ask the court to uphold the guilty verdict. Thank you.
Carnes?
Thank you, Your Honor. This is a disturbing incident involving a defendant and a 14-year-old. Clearly shows some lack of judgment, lack of maturity. However, the defendant does not have any prior convictions. I think ultimately this is a fair resolution of the file. I'd ask the court to place Ms. Jones on a delay of sentence of up to 8 months.
Mr. Carnes, I know the CCH is relatively blank because she's just now 18, but there's some juvenile history, is there not?
Your Honor, I don't show that on me, and I am familiar with Ms. Jones on some other things, but not where she was the defendant.
After accepting the plea, Judge Hartle reviewed the police report and described the evidence presented in the case. The report stated that the video showed Amanda striking, kicking, and kneeing the 14-year-old victim while she was lying in a fetal position. It also mentioned the alleged TikTok post captioned "Round 2." The judge explained why the no contest plea was being used because of possible civil liability, but he also questioned whether the proposed delayed sentence was appropriate given the seriousness of the incident. Both attorneys asked the court to approve the agreement, saying Amanda had cooperated and had no adult criminal convictions.
So the court has
Well, I'm just trying to remember. I remember seems like climbing on top of the school for the 4th of July. Was there charges on that?
She was 18. That was resolved with a civil infraction, I believe. I'm just going purely off memory, Your Honor.
I'm going to be very honest with everybody. I don't plan on following this Killebrew agreement. She's an 18-year-old who literally kicked and beat a 14-year-old in a fetal position on the ground because of something that was said about somebody else's deceased mother, and then had the gall to post another video of it on TikTok. That's not somebody who's making a mistake. That's not what this type of thing is designed for. A delay of sentence is to allow the court to determine whether or not the person will be successful on a term of delay in sentence, and hopefully follow through with the plans. From what I've seen from Ms. Jones and Mr. Carnes, if you tell me that charges weren't brought, I trust you on that. But I can tell you, and I'm not using any of my prior knowledge because clearly it's not full, but I do know from my time as the elected prosecutor here and as judge, and I believe she has another case coming up that she has to be arraigned on with Judge Van Oltz, because I had a conflict on that because I was the elected prosecutor when that arose. This is not a one-time mistake. Ms. Jones has been in and out of this, whether it's this court or the probate court or somehow tied with other events. I'm not going to make a decision today. What I'm going to do is I'm going to set this over for sentencing, and I'll allow both parties the opportunity to do sentencing memorandums and try to convince me why I'm wrong in my thought process. But as I sit here today with the information I have, I cannot in good conscience let this just get, for all intent and purposes, swept under.
Judge Hartle said he was not prepared to follow the delayed sentence agreement. He explained that, based on the facts of the case, he could not treat the incident as a simple mistake. The judge also referred to Amanda's previous history and another pending case, saying he needed more information before making a final sentencing decision. Instead of approving the agreement that day, he postponed sentencing and asked both sides to submit sentencing memorandums to explain why the proposed resolution should or should not be accepted. The hearing ended with the judge making it clear that he wanted to carefully consider whether the negotiated agreement matched the seriousness of the conduct. What are your thoughts on this case? Let us know in the comments below.